Thank you. Please be seated. Good morning. We're here for oral argument in case number CACV 17-0294 in the matter of Southwest versus SBBI Incorporated and others. These proceedings are being video and audio recorded, so we ask counsel to please identify yourselves and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. And counsel for appellee may reserve a portion of the time for rebuttal to address only cross-appeal issues if desired. Also, we have read the briefs and have discussed this case in conference. You may proceed, counsel.
Good morning, Your Honor. My name is Evan Thompson. I'm here on behalf of SBBI, Inc. This matter comes to you on a construction contract on a public works project at the Holloman Air Force Base in New Mexico, where SBBI was a mid-tiered contractor and SWCP was a subcontractor of it. The prime contractor was Hensel Phelps. SBBI and SWCP entered into a written contract, and as part of that contract, the first issue in front of you is a no damages for delay clause. This clause, as you've seen in many of the cases that are cited by both parties, are fairly standard clauses, especially in public works contracts, in order to protect the owner for unjustified claims. The first issue that we provided, and the first thing I think that's most important for the court, is that this clause is valid and enforceable. It is a no damages, a damage limitation clause. Since the 1800 Ocotillo case, it's pretty much standard in Arizona, I think, that parties to a contract, especially sophisticated commercial parties such as this, have the ability to determine whether they want to limit their damages or not limit their damages. Saying that it is valid and enforceable, we look at the negotiation between the parties, and there was testimony and there is facts in the briefs regarding the fact that there were negotiations that went on, there were exclusions that were negotiated, and there were other items within the contracts that were negotiated, but the no damage for delay clause was not changed by SWCP when negotiating the contract with SBBI. SWCP says you should adopt exceptions to the no damages for delay, exceptions to the enforcement, and it provides you cases. And we've all provided you the cases, and the schools of thought in other jurisdictions go two ways. There is the school of thought that you have to have some sort of intent or malicious conduct, and there's a school of thought that it has to be really some sort of action or something that rises to the level of more than inaction, more than typical negligence, in order to enforce the particular exception they're seeking, which is something called active interference. They've put forth to you the Williams Electric case and said you should adopt all four of the exceptions. Now, we've provided you law in Arizona where such a bright line exceptions without facts could create bedlam, in my opinion, in the lower courts. If you're going to consider anything, please only consider active interference if you're going to consider an exception, because at least the facts associated with this case only pertain to the claim of active interference, and the lower court only found under the Newberry case that the SBBI was guilty of what they called active interference, and therefore the no damage for delay clause doesn't apply. When you look at the case law, and I have to be honest with you, I've read a lot of active interference cases. C&H Electric is the one, first of all, they rely on Williams the Williams case, and the Williams case says in South Carolina we're looking at the covenant of good faith and fair dealing, and all of the active interference runs with the covenant of good faith and fair dealing under that case. And you go to C&H Electric, and C&H really says, well, we're not really going to call it bad faith. We're going to say that there is something more than normal things that occur in a construction project, but something less than bad faith. I have to be read, honestly, I've read Peter Kiewit, I've read Tricon Kent, Newberry, C&H, Williams, all of them. And I've been involved in construction for 30 years of my life, and I'm not sure what active interference means. And in C&H, they actually drafted in the contract an exception for active interference. Now, we don't have that here. We have a clear, very unambiguous contract provision that says you don't get damages for delay. All you get is extra time. SWCP wants you to ignore that provision of the contract. Despite the fact that they didn't negotiate it, they want you to ignore it.
Counsel, I appreciate your argument on the cases, and I appreciate the out-of-state cases that you cited. But let me kind of undercut that a little bit. But did the trial court address these issues in its summary judgment ruling?
In summary judgment, no. This is the trial court.
I understand, but did the parties argue these issues that you're talking about on appeal? Did the trial court directly address them in its summary judgment ruling?
It did, and it found there was a question of fact as to who caused the delays. They didn't determine whether the no damages for delay clause applied. All he said was there was a question of fact. It's one line, a question of fact, and therefore I'm denying, as to who caused the delays. And interestingly enough, when you look at the case law and you look at the trial court ruling, the trial court determined that, in her opinion, because it was a bench trial, that both parties caused delays. So when you look at active interference and you look at the definitions, how do you get to active interference if both parties are at fault? Surely it wasn't meant, active interference, the no damage for delay exception wasn't meant to apportion fault. And that brings me to the case that we've provided to you, the Air Freight Express Evergreen case. It's a Division II Court of Appeals case. And in it, they discuss limitation of damages clauses in Arizona, and they look to the covenant of good faith and fair dealing. And when you look at the cases and when you look at whether you're going to invalidate a provision of a contract or you're going to find an exception to an otherwise unambiguous clause, we have case law. We have long history of case law of the covenant of good faith and fair dealing. Really, what they're complaining of is that SBBI somehow kept them from the benefit of their bargain, despite the no damage for delay. What our position is that the court should not adopt wholesale exceptions to a no damage for delay, but should look at the law in Arizona on the covenant of good faith and fair dealing, since many of the out-of-state cases say that these exceptions are rooted in the covenant of good faith and fair dealing. And that's really our position, is that if they were complaining about the application of this provision of the contract, they should have sued in the covenant of good faith and fair dealing.
Now, so going back, the trial court denied SBBI's motion for summary judgment on the conclusion that material issues of fact remained as to who caused the project delays.
Correct.
And SBBI did not seek summary judgment as a matter of law during or after the trial, and there were no post-trial motions filed in that regard, correct?
Correct.
And so your position is, or would you say that SBBI waived its right to appeal this particular ruling?
No, Your Honor, because I think having it go to the trier of fact, and the trier of fact determining that the Newberry case applied, and finding that an exception existed, that we're appealing the trial court after hearing the case law, and the case that the trial court relied on, Newberry, really is one of the cases that finds the higher level of obligation. And so I don't think we waived it because they said there was a fact issue. We found the trier of fact found the facts, and then based it on an exception to the law, to the application of that particular provision of the contract. Our second issue, so that I can get to my timing, sorry, there's actually two other issues, but the second issue is, again, we're looking at an obligation within the contract for the extra work claim. Our position was at trial, and is still today, that this was work that wasn't extra work. The trial court found that it was extra work and that they're entitled to compensation for the extra work. Our position is that you have an obligation under the contract, if you're going to get paid for extra work, to submit and get approved in writing for the extra work. The facts show that, and it's undisputed, that they didn't seek and they didn't get approval in writing. Now, in Arizona, you can have oral modifications, change orders in contracts, especially for construction. That evidence doesn't exist. And in trial, that evidence didn't exist. There was an argument between the parties as to whether it was extra work or work required under the contract. But they never submitted the request for the extra work. And in this particular case...
Excuse me.
Yes.
Isn't it common practice on a job site, especially when we come down to the final portions of the contract, the punch list, et cetera, and it was included in the punch list, we agree with that?
Yes.
So it is in a written document, but there isn't written authorization or approval. It seems like there was an overarching understanding that they would complete this work, and it was in addition to.
Well, I don't think it's in addition to. I mean, that's obviously the
crux.
position we've taken. Right. If you look at the contract requires them to protect the work. And if you look at what it was that the judge found they're entitled to get paid for, was spalling and tire marks. Now, that's not extra. That's something that occurred because of their failure under the contract to protect the work. So our position is that it wasn't extra work. Their position, if it was extra work, they should have submitted the request, especially since they had it on a punch list. They should have said, this isn't a punch item. Punch lists are obligations to fix things that you are obligated under the contract to perform. That's what a punch list is. If you buy a house and they didn't paint something, you got to have that painted.
Correct.
So our position is that that was work that was required under the particular section for protection of the work. But if it was extra, which is what the trial court found that it was extra work. She awarded them damages for extra work. And they didn't follow the provision of the contract, both for protection and then, therefore, for extra work. And there's no evidence of modification of the contract where they were directed to do it at additional cost. The last issue that I have, obviously, is attorney's fees. This is an abuse of discretion. In our opinion, and it's very difficult for me to understand why the trial court ruled what she did, because she just denied our application and didn't provide explanation. When we submitted our application, we submitted it under the totality of the litigation test, and we've laid that out in our briefs. And we think that the court abused the discretion by providing attorney's fees award to SWCP when you look at the totality of the litigation. I mean, this lawsuit started out at $440,000, and they were awarded $62,000. We won on summary judgment, and we reduced their damages to 15% of their initial claim. Our position is that the trial court abused their discretion, and the attorney's fees should have been awarded to SBBI for its vigorous defense of the claims. I'd like to reserve the balance of 6 minutes. Thank you, Your Honor.
Thank you, counsel.
Good morning, Your Honors. My name is Claudio Yamatelli. I represent Southwest Chartered Concrete Paving. Your Honors, I think the arguments of counsel, which really are in part reflect how SBBI as a general contractor conducted itself on this project, truly gives you a picture as to why every single jurisdiction that has considered the issue of a no damage for delay clause has enacted, along with recognizing the validity of those clauses, has enacted exceptions to the enforcement of those clauses. So to be clear, you got thrown a lot of short quotes from a number of cases in the reply brief, trying to create the suggestion that if the clause is valid, the courts have stopped there. That is simply untrue. Each and every one of the cases cited, with the exception, I think, of a 1914 case which simply didn't get into the issue, every single jurisdiction that has considered the issue of a no damage for the delay clause and has the wording, such clauses are generally valid, follows by explaining the recognized exceptions. And there's a good reason for that. And it's the very reasons, just as counsel explained how SBBI conducted itself regarding the extra work, which I'll come back to, but just bearing in mind how they conducted themselves in terms of ordering work and yet refusing to sign any document and now arguing there's no paperwork. That's the kind of conduct that these clauses are seeking to prevent from causing unjust and outrageous results. We're not asking for some bright light rule that says, hey, listen, if you do the simplest, lowest level of improper conduct, that's end the story. Not at all, not whatsoever. We recognize that even adoption of a active interference exception will require factual determinations during the particular cases. And with respect to our, yes, Your Honor.
Talk to us some more about that. What exactly, how do we determine active or willful interference?
Okay. So active, and incidentally, the CNH case has been referred to. It actually has a lot of language when you read it closely that is favorable to our position or is at least in line with our position. And then we have the recent Colorado case, the South Carolina case, and as well as the cases out of Florida. So active interference, it does mean, incidentally, active doesn't mean whether it's a affirmative act or lack of action. Okay, it does say it's something more than merely, oops, there was a problem, there was a mistake, it occurred, and boy, you know, we didn't realize what was happening. So in the most direct way, as it related to our case and all of the cases that address active interference, when a general contractor or owner knows that their conduct is causing delay and damage to the other party, that party cannot simply just sit back and let the other suffer damage. Look what happened here. SBBI, despite having a policy of requiring its subcontractors to post a payment and performance bond for their own protection, failed through a favor in the office to require that of Bray. So Bray, the other subcontractor that caused much of the problem, was not required to submit and provide a performance bond. So there was SBBI, knowing that this party wasn't performing, knowing that the job was not ready for SWCP, and it does nothing. And it keeps happening, and it keeps happening, and it keeps happening, and it does nothing. It doesn't supervise it. It doesn't take action, not over one day, but over a long period of time. Why? They didn't have a bond to go after. We cited to the trial admissions where they said, we were just trying to get them to push along to essentially suck value out of them no matter how slow they went, which in turn was harming Southwest Concrete.
So doesn't that equate to a breach of good faith and fair dealing under the contract? Do you think that we actually have to reach active interference?
Your Honor, it may, and our position is that an active interference clause may in some instances be an actual additional cause of action, or it may not. No jurisdiction in any of the cases cited has held that you must pursue this type of claim as a separate cause of action. So the fact there's an overlap does not mean that it needs to be only that way, or that you don't need to even reach that level. There's many other ways that we invalidate clauses that are not deemed to be appropriate. For example, an integration clause. We allowed testimony, pre-contracting testimony and prior evidence and parole evidence, notwithstanding the fact of a full integration clause. And we do that for good reason. We have concept of unconscionability. Contracts may not be enforced if they're unconscionable. They're not separate cause of action. They're defenses to enforcement of a clause or a contract. You have a duty to mitigate damages. That's not a separate claim. That's within your responsibilities under a contract. So there's different type of clauses in the exceptions to the enforcement of a no damage for delay clause is no different. The courts have stepped in because of the abuse that would actually result. They have even gone so far as to say that SBBI had no duty to even manage the job, which we find just completely disingenuous at best, because SBBI, the only time they acted, and when they finally acted, was they were under threat of being themselves declaring default by Hensel Phelps. Why is that? Because under the Hensel Phelps contract, Exhibit 1 to the trial, which is incorporated into the subcontract, they had the obligation to manage the project and manage the subcontractors. What are they suggesting? No exceptions to the no damage for delay clause, no duty or obligation to manage the job. Who's steering the ship? Who's directing the work on the job? If they don't have any obligation to do anything and they can sit back on the no damage for delay clause, well, I think you know where they're headed and what they argue for. So again, yes, the covenant of good faith and fair dealings is the root or the rationale behind these exceptions, but it need not be a separate cause of action. It just simply is a way to preventing injustice, preventing a party from abusing a otherwise contractual clause. There will be many instances where the facts will not simply rise to the level of active interference. And along those lines, I want to point out on the issue of delays, or what we call as, delay by both parties, and the concurrent delay issue. First and foremost, it's never been raised as an issue that somehow, because it may have been concurrent or delayed by both parties, that somehow prevents application of an active interference exception. So that issue has never been raised that I can recall, certainly not in the briefs, and that I hear essentially as a claim, or at least a rule of an argument being raised to invalidate the exception for the first time. That's number one. Number two, just because they had the good fortune that something went wrong with a plant of mixing concrete, which resulted in some delay, because essentially one of the delays that happened with our client, Southwest Concrete, is that the concrete that was being put out did not pass testing, so they couldn't begin some work. So in the progress of their work, there was an issue that prevented them from going forward. Just because that occurred does not mean that a party who is acting in violation of their duties should now somehow get a free pass. So again, the trial judge did try to apportion, saying, well, even though they may not have moved quickly and they weren't properly supervising, you would have incurred some delay on your own anyway, so I'm going to remove that time from what they otherwise should be responsible for. This trial judge had no problem addressing the issues. The trial judge determined that there was clear knowledge that they were allowing the project to go forward, knowing it was causing harm. That is active interference. That is something more than just mere negligence. And when you add on top of that the testimony and the admissions concerning the bond, you now know the motive. And that's even, we submit, would justify the bad type of conduct that some of the jurisdictions that dealt with the issue in the past and have come to require.
Mr. Yanatelli, what about the question that Judge Cruz posed to opposing counsel about did SBBI, by not seeking judgment as a matter of law after trial or filing any pretrial, post-trial motions, did they waive this argument? Is it even proper before this court?
Your Honor, the arguments at trial, and there was no argument, that my understanding, starting with the ruling when the
because I don't believe the trial court directly addressed him in the summary judgment ruling, correct?
What I was going to say is that Judge Whitten, I think it's only by inference that you would conclude that the no damage for delay clause was not preventing damages. I say by inference because he said we need to go and determine who caused delay. So you've been delayed. Why determine who caused the delay if you're precluded as a matter of law? There were no motions presented saying straight out as a matter of law they cannot recover damages. The big argument at trial and in closing was the issue of active interference. They haven't established active interference, and the courts require more. So in that sense, the issue was not dealt with, was not raised at trial, was not waived. They did seek, but in being intellectually honest, they did, and to be clear, they did raise the issue in the summary judgment, which was then denied. Okay? So that's as honest as an answer as I can give on the issue.
I appreciate it. Thank you, counsel.
Going to the issue of extra work, all right? As Judge Campbell pointed out, the request for the additional work is in the punch list. And let's deal with the issue of the cleanup, okay? On the cleanup issue, Southwest not only objects to it, it sends them an invoice for the third party they're going to have to contract and says, we're going to charge you for it. We expect to get paid. The testimony at trial is that they can just control. Deborah Fain, the president of SBBI, testified that if she just doesn't approve an extra work order, then the subcontractor's stuck. We objected. They direct us to perform. So now they want to put us in a position of being in default and then come into court and say, but we're not entitled to get paid because they didn't approve the change order. That's the kind of conduct that you're going to, unfortunately, open the floodgates to if you don't adopt exceptions in the case of a no damage for delay clause. The same kind of nonsense they argue with the extra work. Then, if you really look at the contract, when they argue some written concept, there's no testimony of whether it was their mistake or not, but the fact is, paragraph 8 of the contract, if you read it, read the last part of it that they rely upon, the requirement about approval by their home office has nothing to do with extra work. It has to do with a change order that changes the scope of the work. The sentence starts by saying, in the event of a change order under paragraph 7, you either need to have a written signed change order or you need to have an extra work order. That's what it says. There's no testimony that that's not what was intended. So if you read it too quickly, you don't pick it up. But if you break it out, it's really very simple. There's a beginning phrase that modifies the rest of it, and it says, if you're going to do work as a change order work on the paragraph 7, you either better have a written change order or you better have a work order. Done. I think it is also important to remember that at no time did SBBI request specific findings of law, findings of facts or conclusions of law. We went to a bench trial without making that request. That is very problematic from coming into on appeal and seeking a reversal and arguing the evidence and what the judge did or did not do, because if there's anything in that record, the conclusions of the trial judge have to be affirmed. And they have no record upon which to argue that the judge erred. They have ignored that standard. On the issue, and there was specific finding that the contract did not require Southwest Concrete to clean the concrete. There was specific finding of extra work. They cannot challenge those findings. On the issue of attorney's fees, the one point that counsel forgot to mention is that no matter how much our claim was, their offer, after litigating for quite a bit, was $20,000. Put aside all the fees that were incurred, $20,000 we recovered, including interest and so on, whatever it is, some $70-some thousand. Our fee application was $76,000 requests. We got 20. The judge exercised her discretion, considered the issues. They had the opportunity to consider whatever offsets they thought. She came out to $20,000, very reasonable amount, took into account everything she should have. The statute is very clear on how we deal with competing claims. And that issue is just simply just not a proper issue to raise. Finally, on our cross appeal, okay, what I would say on that, in summary, that decision was wrong with as one critical fact, that the trial judge, Judge Whitten, failed to recognize the inherent inconsistencies in the contract. The preliminary plans erroneously called for dowel baskets to be used as a method of installing the dowel bars. The contract states the plans are going to be utilized. Those were preliminary plans, but it references them. But then the contract directs you to Schedule A. Schedule A is a more specific section. It identifies dowels, not dowel bars, dowels, and then it identifies as another scope of work the drilling to install the dowels. The testimony presented in summary judgment is that installing dowel baskets and drilling to install dowels are mutually exclusive. They're entirely different methods. There was an inconsistency in what the scope of the work was. And Southwest was retained to do a portion of the work, not all of the work. The contract says a portion of the work. So you have that inconsistency. Schedule A is more specific. You then have the exchanges that occurred prior to signing the contract where we say, hey, you're wrong. Your plans still show, the new set of plans still show dowel baskets. The government will not approve that. We don't have dowel baskets because it's not going to be approved. Effectively, they recognize, okay, but what's going to happen if the government, what happens if you're wrong? So our guy is so sure that it's not going to be required, he says, look, if I have to add that to my scope of work, I'll cover it. Okay? That recognizes at least an interpretation everybody knew that it was not included. Summary judgment on that was not appropriate. I'll reserve the rest for a question or two that I may be able to answer.
Thank you, counsel.
Thank you, Your Honors. Quickly, you heard a lot about how SBBI conducted itself. One of the things that I really want the court to look at is in the conclusions of the Superior Court, their claim was 23 days of delay. The court awarded 7. Counsel kept saying the facts are that SBBI is this big, terrible general contractor beating up on its subcontractor. That's not what the facts show. One of the things that you asked, and you asked very carefully, and it's what I've struggled with, is what is active interference? How do you determine what active interference is? And he says, well, it's knowing. Well, a lot of what you heard was, well, their subcontractors delayed the project. This is something that happens in construction consistently. And you don't just fire your subcontractor immediately. You have to try to work with them because you're under contract with them. You have to try to resolve this. And the duty issue, the duty that our client owes is to Hensel Phelps, because that's who's paying them. That's who their obligation to make sure that the work gets done in Hensel Phelps' contract time. That's where the duty is owed. You can't reverse that duty to your underling subcontracts. They owe the duty. SWCP owes a duty. Bray owes a duty. Quest, who SBBI brought in immediately, as Hensel Phelps testified at trial, upon the knowledge that Hensel Phelps was unhappy with the delays. So there wasn't this knowing, hey, we don't have a performance bond, because if a sub isn't performing, our client's going to lose money anyway. And the covenant of good faith and fair dealing is their defense to the no damage for delay clause. It's interesting that in this case, the single cause of action by SWCP is the breach of the contract by SBBI. But the issues that you're here to listen to are reasons why proportions of that contract shouldn't be enforced. That's what they're asking you. SBBI breached the contract, but everything we agreed to in that contract, you shouldn't enforce against us, only against them. On their cross appeal, all of the facts that they laid out on the cross appeal, if you look at the record, were in front of Judge Whitten. Both parties invoked the Taylor v. State Farm provisions and provided him piles of evidence. He took all of that into consideration. This isn't the testimony in Mr. Nuttall's declaration was the one you just heard. Hey, there's a difference between the dowels and the dowel baskets and the drilling. And what's interesting is this is a negotiated contract. In Schedule A, there are exceptions to the contract. One of the things that you don't see in the exclusions to the contracts is dowel baskets. If they were drilling and doweling and the dowel baskets are in the contract, why in the negotiations didn't they add the dowel baskets to the exclusion? We asked that of Judge Whitten. Judge Whitten looked at the plans and specifications. He looked at provision 1 of the contract that incorporates the plans and specs, as well as the contract between Hensel Phelps and SBBI. He looked at the same language that's in Schedule A, the same language that's in Schedule B, and he determined that everybody knew the dowel baskets were part of the contract. And he did it under Taylor v. State Farm, where he listened to all of the parole evidence. And he determined, in his discretion and in his understanding, that they're not entitled to recoup the money that Hensel Phelps took out of SBBI and SBI took out of SWCP. He looked at all of that evidence. It's the same evidence they're asking you to look at. And in his determination, he determined that the contract, the intent of the parties in entering into that contract was that the dowel baskets were part of the scope, and that if ultimately they were be removed, that SWCP would not be entitled to be paid the money for those dowel baskets. So all the evidence went to Judge Whitten. Judge Whitten did what he was supposed to do. He determined what the intent of the parties was, and as a matter of law, determined that they're not entitled to that money under the contract. I have nothing further.
Thank you.
Thank you, Counsel.
The Dow baskets are not excluded because they're never included in the scope of work. And that's the issue that it's missed. The very specific Section A description of work includes Dow's and the method, which SBBI and Hensel Phelps would know and did not controvert, necessarily excludes baskets. So the scope of work did not include it. As to what Judge Whitten did, that all may have been great for bench trial. It was not appropriate in summary judgment. He even went so far as to say the testimony of Mr. Nuttall, which he said he not only, there was no dispute that the communications went before the subcontract was signed, but Nuttall testified that he also communicated the same before submitting the bid. He disregarded that and rejected that testimony. That was direct testimony, and while I'm aware of the Wells Fargo case, that relates to a custodian of record, not to a direct declarant. He could not disregard that testimony because there was no documentary evidence.
Thank you. Counsel, we appreciate your vigorous argument and your briefing. We are now taking this matter under advisement and will issue a written decision in due course. We're at recess.